Okay. That was not one of my better moments. Because I was trying to fix the chat. And somehow seemed to have broken the chat even further. We do not have audio from the courtroom yet. Why do we not have audio from the courtroom? I don't know what's going on. And we have the video now. I think they're doing pre-trial catch-up stuff, but...
Okay, we had a late
There we go.
running juror and then a little bit of a technology problem. The juror is here. The technology is ready to go. Are we in fact ready for the jury?
I believe so. Can I just press on pause to make sure the sound is still working?
Sure,
We
yeah.
had it set up beforehand. We're good to go.
Okay, thank you. Would the clerk please bring in the jury?
Kalbaugh, my notes say we stopped at 25:29.
We did. Although I had 25:24, but very close there.
Please rise for the jury.
In that kind of morning. Everyone's welcome to have a seat. Members of the jury, good morning. Welcome back. I'm really, really glad to see all of you, and I'm really glad to see that it is all of you. This is, I think, now the fourth day that you each have been asked to come back, and you're here, and you're ready, and it's greatly appreciated. I want to talk to you about a couple of things before we pick up where we left off yesterday. I told you during some of the instructions that I gave you at the beginning of this case that occasionally what might happen is that evidence that had been received into evidence should not have been, and that I would be telling you to disregard that evidence. This is going to be the first, there may or may not be future times, the first time I'm going to exercise that and explain a little bit about what's going on. Yesterday, you heard this witness testify about what a sap is and what an asp baton is. That testimony remains in. I'm not doing anything with that, and you can consider that for whatever you think it is worth. But after explaining that, the witness also explained that with respect to one person seen in one of the bits of the video, that he thought that person was holding an asp baton, and that with respect to a different person in a different portion of the video, that that person, in this witness's opinion, was holding what he believed to be a sap. That expression of opinion as to what each of those people were holding, those expressions of opinion I am striking, and you're not to consider them. It is up to you to decide what, if anything, you believe the people seen in the video were holding. So again, you can consider the evidence, the explanation of what is a sap and what is an asp baton, but in terms of what each person was actually holding, I'm striking that. You don't have any testimony one way or the other about that. And it's up to you to make that decision if you believe that decision is important. Does that make sense to you? Okay, thank you all for listening to that. I'm going to remind the witness that the oath you took yesterday remains in effect. I won't swear you again. You continue to testify pursuant to that oath. Thank you also for coming back. You may, the witness may remove his mask if he wishes to. And with that, Mr. Kalbaugh, we may resume.
Thank you, Your Honor. Detective, yesterday my notes show that we ended at 25:24. I backed it up just a little bit because my brain doesn't work that way, right on the number. So what I was gonna do is resume where we were yesterday to finish playing the video. Can you see it in front of you?
I can.
Okay. The audio should be working, so here we go. Could the court turn it up a little? Mine's maxed out.
Perfect.
Perfect, thank you.
Than me, so put her there.
Right in there.
He's done.
Detective, additional video that you recovered, we discussed yesterday. I know one, I believe you said yesterday that one of the videos you located online was a live stream video from Mr. Gibson streaming it on Facebook. Is that correct?
That's correct, yeah.
Right. And there's also, and that's State's Exhibit 1. I'm going to play that for you in a moment. There's also State's Exhibit 6. Have you had a chance to look at State's Exhibit 6?
I have, yes.
And is that a cleaned up version of a different video that you also located online?
It is a version of what I located online. I'm uncomfortable with the idea of cleaned up. If
I meant
perhaps
better
you could-
resolution.
Yes.
That's what I meant. Sorry about the poorly worded question.
Folks, let's slow down. Let's not talk over witnesses. Let's not talk over lawyers. Let's do questions and then answers. When the answer's done, let's do the next question.
Thank you, Judge. My apologies.
Thank you, Mr. Kramer.
I said cleaned up. My apologies, Detective. I meant better quality version or better resolution.
Yes.
Okay. I'm going to play State's Exhibit 6 first. Your Honor, that's already been admitted into evidence, permission to publish to the jury.
You may.
And this is a pretty short one. It's about 6 minutes long, and then I'll do State's Exhibit 1.
Look at that.
And the last one I'm going to play is State's Exhibit 1, which would be the previously admitted into evidence by stipulation. Your Honor, permission to public State's Exhibit
You
1
may.
to the jury.
I'm allowed right here on this sidewalk. It's my right.
Detective, thank you for that. I asked you, the last thing I have for you is I asked you some questions yesterday specifically regarding whether you were able to identify Joseph Gibson, Mackenzie Lewis, and Russell Schultz. When I did so, I should have asked you to specifically identify them in court, just so that the record is clear. You're not talking about one or the other men at the table. So at this time, I'm just going to follow up with that and ask, yesterday when you said you could identify Joseph Gibson, do you see him in the courtroom today?
I do.
And can you just identify an article of clothing he's wearing so that the record shows that we're talking about the same person?
It's like a dark blue shirt
Does he have a beard?
and a beard.
We'd ask the record to reflect that the witness has identified Joseph Gibson as the person he's been referring to as Joseph Gibson.
Go ahead, Mr. Kalbaugh.
How about same thing for Russell Schultz? Do you see him here in the courtroom today?
Checkered shirt and gray and black striped tie.
Okay. Your Honor, we'd ask the record to reflect that the witness has identified Russell Schultz as the person he talked about as Russell Schultz earlier.
You may proceed, counsel.
And how about Mackenzie Lewis?
Mr. Lewis is wearing a black suit and a black tie.
Okay. Again, we'd ask the record to reflect that the witness has identified Mackenzie Lewis as the individual he was referencing earlier.
Thank you, Mr. Kalbaugh.
Thank you, Your Honor. I have no further questions for this witness.
Thank you, Mr. Kalbaugh. Mr. Schmaltz, any questions for this
No, Your
witness? Mr. Lee, any questions for this witness?
No, Your Honor, thank you for coming.
Mr. Doyle, any questions for this witness?
Yes, I do. Just one question. And I don't know if it was, you'd already said it yesterday. Were you able to identify the person, the man who was wearing the brass knuckles in either of these videos?
I was not.
No further question.
Mr. Kalbaugh,
No.
may this witness be released. Oh, okay. The witness is excused at this time.
At this time, thank you, Judge, and I'll be in touch with Detective Trainer if we need to hear more from him later.
Okay.
Counselor, am I excused?
So,
I'm sorry.
that's okay. We will get back to you. You're excused at this time. Mr. Kalbaugh will follow up with you shortly.
Okay.
Thank you.
Stick around for a minute. I'll be with you shortly. The state restaurant.
Thank you, Mr. Kalbaugh. Members of the jury, the state has rested its case. That means it has presented to you all of the evidence that it intends to present in this case. What that means is that in this case, as in, or in this trial, as in all trials, this prompts an occasion for the lawyers and I to do some work outside of your presence. We'll do it as expeditiously as we can. May take a few minutes. I'll ask you then to please retire back to the jury room. You can leave your notebooks on your chairs. Thank you for your attention and your work so far this morning. Please remember my instructions not to discuss this case with anyone, not even with each other, and not to do any independent work or research into anything or concept or law or person or place having to do with this case. We'll get you back in here working as soon as we can. Thanks for your patience. We'll see you here soon. We'll go off. Mute WebEx.
mildly confused again. Thought they were doing motions instead of going on off the record. So. I mean, Ian Kramer got 5 years probation for some much stronger charges than what are being charged here. So I don't remember hearing about stuff burning down. Not to mention, I feel like it would be pretty hard to burn down the courthouse, considering how many times the sprinkler system has faulted and like flooded the floors of the courthouse. I can remember that being a thing when they first opened. Oh, okay, so he was in pretrial. Let me go ahead and take a look why he sat in jail. Was that just a failure to make bail? Let's see, this is going to take me a minute. I got to log back into OECI. He had a lot of charges. Measure 11 would... Let's see. Yeah, because he had the riot charge, assault in second degree, unlawful use of a weapon, attempt to commit a Class B felony, unlawful use of a weapon, use of tear gas in the second degree, and disorderly conduct in the second degree. The assault charge would have been the measure 11. And he pled to that and the unlawful use of a weapon, and I think from the other case, yep, then also the riot from the second case. So let's see, what was his bail set at? CSS report, that's not going to be bail, but unable to evaluate, okay. So they didn't touch that. $250 is the standard bail for Measure 11 cases. check the recog motion. Maybe it's in there. Okay, 269. Yeah, what they do is they take all the different charges and the bail amounts stack on top of each other unless a judge authorizes a change in bail based on, if there's an enhanced risk of flight or the defendant makes a case for a reduction in bail. And it looks like $269,000 was what the initial bail was set at as a statutory minimum when he was first arrested. And there is nothing in the record that he ever requested a reduction in bail. So that.
We are back on the record in letters.
Yeah, that
we're on the record. We are outside the presence of the jury. All counsel, all parties are present. I understand we'll have some motions to take up. Mr. Schmontzes, you're on your feet.
Your Honor, thank you. I am at this time moving for a judgment of acquittal as to the sole count charging Mr. Schultz with riot. In this case, as the court is aware, this court must grant a motion for judgment of acquittal if the evidence presented by the state is insufficient to allow a rational trier of fact to conclude the defendant committed each element of the crimes charged. The court has viewed several different videos where Mr. Schultz is depicted based on the definitions that we have applied to what violent and tumultuous conduct is. No juror could find that he engaged in anything other than protected speech, no rational juror anyway. Some of the cases that discuss this, as the court is aware, under the riot statute is the Say Chow case, which discusses the need for force or violence. A person charged must actively engage in violent and tumultuous conduct. That's the language from Chakarian at 375. Violence is defined as extreme force marked by an abnormally sudden physical activity. Again, I can review the tape with the court if you like, but there simply is no time when Mr. Schultz engages in actual physical activity. Having watched the video several times, I think it can be broken down in basically three different events. The first is when Mr. Gibson approaches, and you will observe Mr. Schultz at that time standing on the sidewalk next to Mr. Gibson. Mr. Gibson spit on a few times. It appears he's saying some words, but you'll see at some point his hands in his pockets. I don't think he ever even uses like a lewd gesture. Certainly he never throws anything. He then kind of retreats to the back after there's some pepper spray. During this fight that breaks out between the bouncer and I can't recall the name of one of the associates, but you actually see him outside the circle, kind of standing to the side. He's not preventing anyone from entering. He's not preventing anyone from breaking up a fight. I am anticipating that argument from Mr. Hughey. The Say Chow case has some language about if a person forms a ring and prevents the victim from getting out. I don't think that was the situation here. Mr. Schultz.
Say Chow, it's a ring where a juvenile is being beaten,
and he couldn't get out, right? And that's not the case here. And then the third aspect, you'll actually see Mr. Schultz trying to remove people from his compatriots from the scene, saying, "Let's go. We had a deal," and they're escalating. And again, when the baton strike happened on Heather Clark, he's in the back. So he never touches anybody other than his own folks.
Although touching is not required.
And touching's not required. But some act of physical conduct is required, and we don't have that on this record. That's discussed in the case State v. Hossley, 282 or App 880, which is actually a disorderly conduct case, but when we're defining violent and tumultuous conduct, it discusses that. And there's some good language here I'd like to read into the record, which is, over the past 30 years, our cases applying disorderly conduct have construed the statute in a manner that will not infringe upon constitutionally protected speech. Referring to Cantwell, we concluded that the terms fighting and violent, tumultuous, or threatening behavior refer only to physical acts of aggression, not speech. We also concluded that the disorderly conduct statute makes unlawful only the use of physical force or physical conduct, which is immediately likely to produce the use of such force. Just on that basis alone, I think the court could safely dismiss this case as applied to what Mr. Schultz did. I also don't think the state has shown that Mr. Schultz was aware of and consciously disregarded a risk that he was causing public inconvenience or alarm.
By his physical conduct.
Correct. So I am asking on that basis. If the court has any questions, I'm happy to add to the record. But
Thank you, Mr. Schultz. Thank you. Mr. Hughey.
Your Honor, could I have the court's permission to remain seated so I can read my notes
Certainly.
a little better? Thank
Of
you.
course.
I agree with one very narrow part of what Mr. Schmancy said is that State v. Seychau, which is 167 or App 227, is instructive here. I think that Seychau is largely the reason why the state wins this argument. So this is the Court of Appeals 3 years after the Oregon Supreme Court decided Shakarian. And as the court just recited correctly, this is about basically a group attack on a student at a high school. And Seychau instructs two important things. The first is what it means to participate with 5 others. I don't think this is a huge part of Mr. Schultz's argument, so I'm not going to spend a lot of time on that. But it basically makes clear that even what we would probably characterize as the victim can be a reluctant participant, as the court puts it in Seychau, as long as they're actively participating and not just passive. I don't think that's the thrust of Mr. Schultz. I think Mr. Schultz's motion hinges on the second focus of what the Court of Appeals looked at in Seychau, which is what is the sufficiency of conduct to be violent and tumultuous. Factually, the evidence here and in Seychau share a great deal of similarities in my view. In Seychau, the student that I'll call the victim was confronted by the youth or the defendant with 4 cousins, so 5 total plus the victim. The evidence was they came up behind him, they spoke in their native language, they moved in front of him to 6 or 7 feet away. One cousin, not the youth that was charged, asked if he wanted to finish it. One, again, not the youth that was charged, tried to hit the victim. The victim fought back, tried to run away. His escape was blocked by the locker wall. He fell to the ground, was kicked by a different one of them, again, not the youth. And then the testimony was that the cousins, including the youth that was at issue here, were moving everywhere. Most importantly, the youth in Seychau never spoke to the victim, and there was no evidence the victim did not know whether the youth actually struck him. But
the youth in that case was described as blocking the victim's escape.
That's one of the things the court looked at. So
one of the things, or is that a critical component of the court's determination in what the court described as a very close case?
Yep. A
critical component in the court determining that even though, as you say, I'm going to use the word defendant, though I understand it was a juvenile case.
Sure.
That person didn't speak to, didn't kick, didn't touch. But the court found that defendant used his body in such a way as to prevent the victim from escaping.
I think that was part of it. Yeah.
Evidence in this case from which a reasonable juror could conclude that Mr. Schultz did that.
There is. So the court in Seychau recites kind of the factors that it relies on page 234. And I agree that the court says this is close. It's also worth noting that this is a de novo review of the juvenile court's finding of jurisdiction at a standard of beyond a reasonable doubt. The standard here is more generous to the state.
Well, the question is whether any reasonable juror, giving all inferences in favor of the state, could beyond a reasonable doubt.
Right.
We end up in the same.
Well,
ultimately the question for the jury would be the same, which is beyond the standard would be the same.
But the question the court's resolving is, could you? Not.
I understand.
Not the trial court correctly did. So again, on 234 is where they kind of recite the factors. The youth and the cousins jointly confronted the victim in the culmination of longstanding mutual dislike. We have that almost identically in this case. The youth with the cousins surrounded the victim, blocking his escape. That's exactly what the court was just talking about. Another cousin challenged the victim to a fight. We basically have that here with these two other guys from each side fighting. Just before the attack, they were speaking in another language victim did not understand. I don't know that we have anything analogous to that, but I don't think that should weigh very heavily because speech can't alone constitute violent and tumultuous behavior. Victim was intimidated and expected violence from the cousins. Clearly, that's a reasonable inference that anyone could make based on the dynamic that's going on in the evidence in this case.
Who could the jury reasonably infer was intimidated and expected violence from Mr. Schultz?
I will get to that in just a moment, if that's okay.
That's fine.
And then after the attack began, basically the evidence was that the youth and the other cousins were moving everywhere, which.
But earlier in the paragraph, it makes clear the court found that youth with his cousins surrounded the victim, blocking his escape.
Right.
So moving everywhere is not, they're not wandering around aimlessly. The point is that in using their bodies that way, they were blocking escape.
Right. So here's where then let's turn to the evidence here. And with respect to Mr. Schultz, I think I would direct the court to two distinct instances where you can say, look, this is unquestionably an act of violent and tumultuous conduct as it's defined and as Seychelles instructs. I don't know that we need to put it up unless the court really wants to look at that moment.
If I don't know exactly what you're talking about, we might have to look at it. If I know what you're talking about, we may not.
Okay. I think from my perspective, both of these come from States 2, gives the best view. The first instance is kind of in the beginning of this confrontation, what some people have called sort of the skirmish line going back and forth. At about the 33-second mark of States 2, there's a masked guy on the other side that says, like, demask us, you little expletive. Then, at about 20 seconds later, Mr. Schultz is flanked by Mr. Lewis with the helmet and the hard knuckle gloves, the guy in the batter's helmet, the sweatshirt guy that gets in the fight later. Both of them, or all of them, are wielding flags that are clearly fashioned as weapons. And then at the 103 mark, Mr. Schultz is posturing menacingly while being restrained by the other participant. As he pushes against that restraint, putting his finger in the guy's face, saying something that's admittedly sort of difficult to hear, where it sounds like he's threatening, and you can make out the words, "Pull off your mask." So that's the first instance. The second is related to the street brawl. Again, I think this is captured best with respect to Mr. Schultz in States 2 at the 17-minute 30-second mark. That actually, right at that mark, illustrates that this is not a spontaneous fight that broke out, or at least if it was, there was an interruption, and then it was recommenced in a more organized fashion. You see the guy that's fighting on the side, I'll say, of the defendants, hand his hat off to somebody and kind of go back in, okay, we're going to re-engage in this fight. From 17 minutes and 41 seconds onward, Mr. Schultz forms basically what I would describe as this, human boxing ring or MMA cage in the street. Unlike ropes in a boxing ring, it's people. He stops the intervention of Demi Cooper and then at 17:56, and then spreads his arms to block anybody else from intervening, either to break it up or assist one of the sides.
Is
right?
it the state's position that a reasonable juror could determine either that one of the two men involved in that combat wanted out but couldn't get out, or if they had wanted to get out, could not have gotten out because
Absolutely.
of something Mr. Schultz was doing?
Yeah, or would have been dissuaded. I'm not saying it was like an impenetrable wall, right? But this is a circle of people with their arms spread in some cases, including Mr. Schultz. You'll see in that time between 17:30 and 17:50, almost 18 minutes or so, doing both, right?
The state agree with me that this was not to the extent that the record is consistent with what you're explaining, that ring is not closed. There are would the state agree with me, there are obviously large gaps between the people.
Sure. Yes, and it moves over time and it shifts over time, of course. But I think what is important is that there are moments in the 17th minute there where you see Mr. Schultz forming that ring deliberately spreading his arms to make that ring and then also stopping people from intervening, not in a way that would both dissuade a participant from exiting or feel like there was an opening to leave, or allow somebody to assist or intervene on behalf of either person. So I think it's fair to say that, like in Seychelles, this would be closer, certainly vastly closer than any of the other defendants in this case. But it's important, in my view, to distinguish what's criminalized in the riot statute from assaultive behavior or even attempted assaultive behavior. Violent and tumultuous is more broad than that, and it's contributing to the greater tumult. And it's in the States very, very close to Seychelles, and certainly close enough that a reasonable juror could find that the elements are satisfied beyond a reasonable doubt.
Thank you, Mr. Hughey. Mr. Schmontes, do you wish to be heard further?
I don't think that Mr. Hughey's description of the circle is supported by the evidence. It is clearly not, and as the court was just indicating earlier, there is, in fact, we watched the Cider Riot bouncers step away and step back during this brawl, and Mr. Schultz is not even in the camera view that he's able to do that. And you also see the other participant with I think he had the Make America Great Again hat. He also walked outside the circle. No action by Mr. Schultz to either stop anybody from coming in or out. I mean, I admit he did have his hands out at one point. Is that contemplated by the riot statute as physical conduct? I don't think it is. Not enough to rise to get past an MJOA. So I'm going to ask you to grant that.
Thank you, Mr. Schmontes.
May I just direct the court to a couple parts?
Sure.
I don't take issue with Mr. Schmontes' point that there are times when Mr. Schultz steps away. I'm not suggesting that it's an impenetrable linked arms from start to finish or anything like that. But the statement that there are no instances of Mr. Schultz stopping people from entering or exiting is not correct. He stops Demi Cooper from intervening at 1756, and he stops Ian Kramer from intervening at 1835.
And I saw and recall both of those instances. I agree that that is what's in the record. Any motion on behalf of Mr. Gibson?
Yes, Your Honor. The first point I would make is that this is not just a motion for acquittal based on the evidence. It's also a motion to apply the Robertson analysis, that the statute is unconstitutional as applied to the conduct here. I think it's important to stress that neither Shakarian nor Seychelles are First Amendment cases. In neither of those cases did the court consider many of the First Amendment things we've been arguing about for 3 years. Your Honor has considered those things in the jury instructions and properly limited consideration of the reactions of other participants and focused on the personal conduct of Mr. Gibson and whether that personal conduct is violent and tumultuous conduct within the meaning of the statute. Now, Mr. Schmontes has explained that there has to be some connotation from the words violent and tumultuous, and he's told you the dictionary definitions. And there's nothing in the record that the state can identify as being particularly violent or tumultuous by Mr. Gibson. I'll talk a little bit more about specific examples, but in substance, it's what Ms. Clark testified to. He walked up, he started filming, he started engaging with people, he walked over, he said this, he said that. It is conduct that is all expressive conduct. The entire event was expressive conduct on his part.
A couple of exceptions to that, or at least, aren't there, Mr. Buchal? We've got Mr. Gibson at some point when he is spat upon, wiping the spit off of his arm onto somebody else. We have at least on 2 occasions, I think, with the same person, Mr. Gibson using his arm to create distance, and on one occasion holding that person at arm's length.
Right, and so that raises...
You would agree those instances of conduct are not expressive?
Yeah. The question then becomes, are those
I agree.
physically threatening or violent within the meaning of the statute.
I agree. I'm just making sure that we're on the same page. Okay.
And to talk about those for a second, they're smiling, they're together. There's no element of physical threat from Mr. Gibson. No one is afraid of him. No one thinks he threatens physical violence on them at all. He stands there. No one shrinks from him. Ms. Clark comes out to engage with him. We don't think that any reasonable juror could find that his conduct threatened any attack by him. What there is there's violence from Antifa. And that brings me back to the First Amendment point, and that's why we included those instructions, which are maybe more appropriately argued here, about political speech, is where the First Amendment should get the broadest scope of protection. And we have a fundamental political question going on in Oregon, right, in Portland, right here, right now, which is, what is, should this group that has been allowed to run wild and damage property and break things repeatedly over and over again, should something be done about this group? And that was quite evidently his entire purpose, as narrated over and over again in the video.
I'm having trouble seeing how this connects to your argument, because if, and the state has conceded this, and with respect to Mr. Schultz, I think correctly, if in fact speech cannot be considered in determining whether or not a defendant has committed the crime of riot, why does that matter? Whether you're right or wrong isn't irrelevant to the actual question that either that the jury, if it goes to the jury, would need to decide, or that the court on your motion for judgment of acquittal would need to decide. If in order to survive, I understand you're making an as-applied challenge.
Yes.
But in order for the statute to be lawful at all, the Oregon Supreme Court has said it cannot reach, and is in fact not intended to reach, speech. So if it's not reaching speech, why does it matter whether Mr. Gibson was involved in political speech or some other kind of speech? Why is that relevant to any of the decisions for this court to make on this motion?
Well, if Your Honor then narrows the universe down to holding Carrie Canary, I believe was the name on the driver's license, was testified, to holding this person at bay, then let's talk about that. Okay, so he comes up and this person begins to shoulder into him, and he pushes the person back. The person is not threatened by him in any way, shape, or form. The person knows that she can go up and do this and get in his face and hit him, and knows that he will not retaliate. There is no element of threat there or ominous conduct with regard to his conduct with Miss Canary. There's nothing there. And the same with this bit about the spit, they're all standing around. It's like some sort of horseplay, and no one feels threatened. No one shrinks from him. How could a reasonable juror find that these things created these ominous threats, except by reference to some larger conduct where there is this violent criminal gang with violent tendencies, a reaction to which Mr. Gibson wants to document? And so we think it's a forest trees thing. The forest here is violent criminal gang, and these little trees are not violent and tumultuous conduct by Mr. Gibson, especially in the context of expressive conduct that the court is bound to protect under the First Amendment and under Article 1, Section 8. So we think the prosecution has not identified anything in the record that is personally engaging in violent and tumultuous conduct. And although Shakarian was not a First Amendment case, it did not focus on. There's nothing in the case about what the people there were doing or the context, but they said the person must be personally engaged in this thing that goes beyond the speech in some way that is this ominous threat. And if you take away the reaction and you focus just on what he did, it's a big nothing. It's not riot.
Thank you, Mr. Buchal. Mr. Hughey.
Certainly,
Again, welcome to remain seated if you prefer.
thank you. I have fewer notes here because I don't think this is remotely a close call. Certainly, even Mr. Buchal is not suggesting that wiping spit on the shirt of another person is protected First Amendment speech. And so, as we discussed,
Is it violent and tumultuous?
it is. It is, as we just discussed, violent and tumultuous does not need to rise to the level of an assault. And what we have here is Mr. Gibson flanked by helmeted, armed men at his sides and at his back, wiping spit on the chest while goading them do something, which again, the speech is not the violent and tumultuous conduct.
Nor can it inform the inquiry.
In a way, I think it can. And Seychelles tells us exactly that.
So Chakarian goes the other way.
Well, not that the speech is the violent and tumultuous conduct, but that you don't look at these things in a vacuum, right? Jabbing, I mean, if we looked at these in a complete vacuum, and I was at lunch with somebody sitting across the table, and I said, "You've got a little ketchup on your face," and I pointed my index finger right in their face. That would be vastly different from me getting right in their face and saying, "I'm going to demask you," wouldn't it? And it's not the speech that makes it violent and tumultuous, but it's not considered in a vacuum. The Seychelles court says exactly that. I'm trying to find the quote here. Yeah, it's on 236 of Seychelles. It says, "The conduct must be viewed in relation to the specific situation, not as an abstract behavior."
Sure, situation different from speech.
Okay. Well, okay, so setting aside the speech, even, I guess that goes back to my point of flanked by other armed individuals, wipe spit against one guy, wipe spit against the next guy, any more violent and tumultuous, and we would probably have a completed assault. So the question is, does wiping spit...
Well, you might have a completed harassment, right?
Sure. But the inquiry here is wiping spit against somebody's chest while flanked by armed people where there's this massive, I would characterize it as a tinderbox for public alarm and a breach of the peace. Does that threaten a breach of the peace? Of course it does. Of course it does. And that's before we move to Mr. Gibson's involvement in the street fight, in the encircled boxing ring in the street, which again, much more than what's going on in Seychelles. I don't think it's an exaggeration at all to say that he's officiating that. His mental state is well corroborated.
What is the physical activity that he engages there, from which a reasonable, I'll just use the language right from the statute. So in the words of Chakarian, what is the physical, with respect to the one-on-one fight, what is Mr. Gibson's physical activity that reasonably was perceived by others as threatening an imminent breach of the peace?
It is the movement with his body and his arms to direct other people to maintain this ring street fight.
So telling people to stay out of it is, in your mind, the physical activity that was reasonably perceived by others as threatening an imminent breach of the peace. That's the state's position.
In that example, yes. Yeah.
Okay. Mr. Buchal.
There are important associational rights relating to this that are not addressed in the sense that Mr. Gibson arrives. The other people who Mr. Hughey perceives as threatening are not people he arrived with. He arrived with Mr. Schultz. And to say that the fact that someone else was standing there converts what Your Honor may perceive as harassment and offensive touch as conduct threatening a breach of speech, again, is a problem in terms of the First Amendment rights. He didn't demask anybody. He didn't tell anybody to demask anybody. He was just keep your distance. And then this attack came. The attack that he, in the exercise of his First Amendment rights, wished to document, to show the people of Portland what the root of their public disorder downtown problems are. So this is about, as applied to these circumstances, are we unreasonably chilling freedom of speech? That's what Robertson 3 is all about. And if you say to the people, if you say that when we have a group of violent criminals, you cannot go and speak or do conduct that's not threatening them in any way, you go up there and you don't do something that's threatening them anyway, and they freak out and do all these things, that's the type of breach of the peace that we're talking about, then that's very, it's vaguely akin to the heckler's veto or whatever. It's a really bad thing First Amendment wise. It's a really bad thing public policy wise, because you essentially empower these groups to grow stronger and stronger and engage in more violence and more criminality. So there is no conduct by him which was personally violent and tumultuous, unless you do the step that Your Honor has already decided that you don't do, which is you take into account that Antifa is dangerous and violent. And so that's what this is about. It's about separating out, for the purpose of the First Amendment, excluding the tendencies of Antifa. And if the tendencies of Antifa are gone from the case, then when you look at Mr. Gibson's conduct, even the conduct of wiping spit or whatever, it's not violent and tumultuous conduct. It comes right out of Mr. Hughey's mouth. Of course it threatened violence. Of course it threatened violence. But the only reason he says that is because he's taking account of the nature of these Antifa members. And if he doesn't take account of that, he can't say that, because if you see someone standing there and they're fooling around, one spits in the other one, and they're smiling and nobody's reacting suddenly, that's not.
There's not a risk if you walk up to someone on the street and wipe spit on their chest that person's going to punch you in the face. That's not a reasonable consequence. That it won't necessarily happen, but it's not beyond the realm of.
This goes back to the instruction on terroristic mob behavior with ominous threats of personal injury and property damage. We're talking about the crime of riot. We have sort of a common sense understanding of riot, and I understand that the legislature put this in a more highly technical form, but what the Code Commission or whatever it was said is we're looking for something like that, and this interaction is not terroristic mob behavior with ominous threats. It's not at that level at all, and no reasonable juror could find it at that level. Now, I know Your Honor has struck the words terroristic mob out of the instruction because we've had this sort of evolving, since 9/11, we've had this evolving thought about what terrorism is and all. But the concept of riot is still there, and it just isn't threatened here. And the only other conduct that he brings up is this idea that no reasonable juror could accept, which is that telling people to stay out of the thing is somehow threatening violence. So that's all they've got. They've got essentially wiping spit. That's not something that a reasonable juror can find involves ominous terroristic threats of personal injury and property damage. It's not what the legislature meant when they said riot.
Thank you, Mr. Buchal. Mr. Doyle.
Is the state's closed? Is their case closed?
Yes.
Okay. I'm afraid I'm going to have to preface my remarks somewhat as that all those who wonder are not lost. I did not hear.
Is there a motion?
There is a motion to dismiss they did not.
Motion to dismiss or motion for judgment of acquittal?
Motion for judgment of acquittal.
Very well. Go ahead, Mr. Doyle.
Because I listened and I heard Portland said a few times. I would like to see where it says Multnomah County. I believe that is one of the, although they don't state it, I believe that this crime in this court would have to be in Multnomah County. And I do not believe the state ever got around to saying Multnomah County. That's just one point. I did not hear it. None of the, they said Portland. Never did they do Multnomah County. And then we'll move on. Secondly, when Mr. Hughey said flags clearly fashioned as weapons, at least as to my client, his flag was stuck in a backpack in back. He had never touched it. I believe once on the walk he was holding someone else's flag, but it wasn't his. And when he went to Cider Riot, at all times he had that flag shoved in the back of his backpack. Never, ever used it as a weapon. And to say that the defendants were gathered together when they said, that I believe it was Defendant Schultz, that was surrounded by people whose flags were clearly as weapons, at least as to my client, his flag was clearly not a weapon at all. This big thing that it was always in his backpack, never, ever anywhere else. Third, I've been sitting here and I've been saying, oh, this isn't a speech case. Oh, this isn't a speech case. This morning I realized that, at least as to my client, this is 110%, a speech case, because the flag was so large that wherever my client went, walked, stood, it was always regarded as a speech case because the flag is totally symbolic speech according to a whole line of cases, Your Honor. I'm not going to quote them.
I don't disagree with the notion that the flag represents symbolic speech. I've been consistent, however, in saying that all speech, which I agree includes symbolic speech, cannot serve as the basis for a jury determination that any defendant in this case committed the crime of riot. So I don't see that as intersecting with Mr. Lewis's case. The question is, there are lots of questions. All of the elements are at issue, but the one that is, I think, foremost in each defendant, it's the one that we've talked about the most, it's the one the state's talked about the most, is whether any defendant engaged in violent and tumultuous conduct.
And except for tossing, there's one toss from my client, not multiple tosses, one toss.
Of the empty canister.
Of the empty canister, and not at, but at the ground, and it hit before it hit, and then it did not hit anyone. And it was aimed at the ground. I think that.
Okay. The evidence is that which it is. I understand that.
The videos are there. And third, I would join in, and I had requested this instruction, terroristic mob behavior, and I know the court has taken it out, but I think that especially in this case and in the cases incited, that as to my client, he was not engaged in that at all, that the reasoning why he put on the helmet and whatever, that could be also, and it is my argument, is speech designed to show that they just want to talk or whatever, but that there is past bad blood and that he is protecting against that bad blood. That is speech. So that in no way is my client engaged or thinking in tumultuous and violent conduct is represented more than mere loud noise. The language is designed to involve, and I'll take out terroristic, involving ominous threats, not just threats. And that nothing that the state has presented rises to the level of riot. Maybe a row, That's the English phrase, but not a riot. And I would especially request a motion for judgment of acquittal.
Thank you, Mr. Doyle. I understand the two bases. Mr. Hughey.
First, even if it were restricted to a single throwing of a empty can of bear mace into the crowd, that would do it. That would be enough. That would absolutely be violent and tumultuous conduct that would be reasonably perceived by others as threatening an imminent breach of the peace. There is more. In States 2 at 2 minutes and 25 seconds, there's a very forceful shove right into the face.
You've anticipated my question. Is it the state's view that that shove came from Mr. Lewis?
Oh, it absolutely can, Mr. Lewis.
Okay, I'm going to finish your argument, and then I'm going to ask you to play.
Oh, sure.
That this was a note I had to myself.
Sure, yeah. States 2 at 2 minutes, 25 seconds. But even if we excise that, picking up that canister, throwing it back into the crowd. Actually, sorry, coming back to the shove though, Seychelles talks about having the potential of setting off a greater melee. You'll see when Mr. Kalbaugh pulls that up, that's almost exactly what happened here. With respect to the argument related to Multnomah County, there was testimony from Sergeant Cider that this was in the state of Oregon. That's the element that the state has to prove here. A challenge to venue, meaning the county has to be raised pretrial or it is waived. That is from RS 131305 sub 2.
Thank you, Mr. Hughey. So, Mr. Doyle, I'll give you the last word, but I do want to see the clip before we do it.
Thank you, Your Honor.
Is that 223? Does that work?
That's perfect, yeah. Okay.
When you talk about pushing the face, do you mean the demasking?
Well, that too.
Okay.
Actually,
same gesture, two different. I shouldn't use the word gesture. Same physical activity accomplishing both of those goals, or those two different physical things.
I mean, just as a matter of.
I'm trying to figure out if we're looking at the same person. We're in terms of the person who you're describing as having been shoved. It's the person who was masked and then loses the mask.
Yeah, the mask is first pulled down. I think they then spit and then a shove.
And then a
by
shove.
Mr.
Okay,
Lewis.
so
I think
same-
Mr. Lewis pulls the mask down in the first place.
And that was my, sorry, you're anticipating my next question. Is in the state's view, would the evidence support a reasonable juror finding that Mr. Lewis pulled down the mask, or that Mr. Lewis engaged in the follow-up shove, or both?
Both.
Okay. Would Mr. Kalbaugh, would you run it back to about the same point? I'd like to watch it one more.
That's the pull, Mac Lewis. And then that's the shove. Yeah.
Okay. We can take that down. And Mr. Doyle, anything in rebuttal, I'm happy to hear.
We are in the middle of whatever this is. If it's an argument or disturbance, whatever it is. Those gestures that go back and forth, I believe the mask that came down and allowed the person to spit in my client's face. And that there is some question, is that after this occurred, that he was restrained and they were restrained, and instead of causing things to escalate, as the state says, at least I think it caused things to get to a stasis or to slightly de-escalate, because he was restrained, she was restrained, and instead of bringing things up to a boiling point, those particular things help, I think, from the film, shows that instead of raising it up, at least brought it down to simmer. So I do not think any of those behaviors are acts of riot,
Thank you,
and
Mr.
that
Doyle.
no jury could reasonably find that.
Thank you, Mr. Doyle. Okay, each of the defendant's motions is received. I need a few minutes. We're going to take a break. We're going to resume at 11:30, and I'll give you rulings on the motions.
Mr. McDermott, just in anticipation of having to use the AV equipment, would you be able to turn that on for me when you have a moment?
Or probably not.
Okay, so yeah, 5 minutes. We'll find out what what Judge Sweet comes back and says about it. I really. I really thought the state was going to have more evidence. I'm not sure. I guess I could try to countersue, but I'm not entirely sure how that would work because the judge allowed it to get to trial. They still need standing to bring it to the court. I guess the closest I could think is some sort of civil rights violation for protected speech. But with as many judges as it's already gone in front of, I mean, all they'd be able to get is monetary damages anyway. And sorry, I have this whole thing is kind of baffling. Suing, I mean, they already were trying to go for defamation as part of this because they claimed that the city was maligning them when they made statements denouncing the behavior of the Patriot Prayer group. And originally there was talk of bringing Mayor Wheeler in as a witness. They did manage to sort things out that they excused him as a witness, but there's definitely a lot of paperwork that was subpoenaed by Joey Gibson's attorney, Mr. Buchal, and I'm gonna be waiting to see, you know, if the judge does do acquittals, then, you know, if all of them, then we won't get to see what their defense was. If some of them that may question what evidence is available to be brought in. I mean, there is also the ongoing civil lawsuit between Cider Riot and Gibson, but that one, memory serves, Cider Riot sued Gibson. There was a bunch of motions sent around about it being a slap suit, and I had trouble. I looked at the last judgment that, before it went into an appeal, and I was a little confused as to what had happened, probably because I haven't heard any of the court audio or taken a really good look at the filings, but yeah, but right now the civil case is in the appeals court. Hasn't been acted on yet, so whoever lost that one has appealed it, and that makes it still live, at least for now. I will say, and I'm saying this personally, if he does get acquitted, it definitely causes me some apprehension, because growing up, I was well on my way to becoming the kind of person he is now, and the person that I was would see the person that I am now as evil and something that needs to be gotten rid of. So while I recognize, First Amendment free speech rights, I also get concerned that the stronger this movement becomes, the greater the risk is that it's going to be turned against me and attempt to criminalize my existence. We've already seen that happening in a number of states, and there are people that want to take the recent conservative wins and make it not about states' rights, but to make them national law, to turn this country into a theocracy. Yeah, and you mentioned that, Beta, and all of a sudden my brain went to how during the George Floyd protests, Portland police saw a banner as a weapon and felt they were justified in destroying that. And I seem to recall that was the judge, the federal judge in that one basically said that was very much not okay, but I don't believe he held anyone in contempt for it. Well, Alvin, in fairness, Lewis's attorney did make the assertion that the flag in his backpack is what made this a free speech case. So it's the defense that's making that allegation. And this is part of where my concern with this case has been, before I saw the state's video evidence. We have seen flags being used as weapons. Maybe not in this case specifically, but if this did turn on it purely being speech, then I think of all the protests that I've filmed where I've seen people using much worse language towards cops. And while, yes, eventually a few people took the opportunity to throw items, then I saw the police turn and use what to me appeared to be excessive force against large groups of people, including those who could be proven had nothing to do with anything being thrown. In fact, if someone from behind is throwing something and you hit the person in front, I mean, you're that's where my now, and saying they have a right to be there, that's something that I've been kind of puzzling on, because when I've gone over the OLCC report in their investigation, it seemed to suggest that if you're basically loitering on the sidewalk that is right next to a bar, then they do have the right to bounce you from that. I mean, if you're just walking by, that's one thing, but if you're standing there, that may be different. That may be treated as property controlled by the owner. I don't know. I don't, that seems very kind of nuanced in this case, and from what I read, it didn't explicitly address, but it did suggest why nobody from either side was evicted from the event, aside from the one journalist who tried to go in to get information about who broke his camera, and I believe one other person. So the OLCC report heavily indicated to me that the bar had the right and actually the duty to eject Gibson and Patriot Prayer from the sidewalk. Sure thing, Christine. And the stuff that I'm talking about right now with the OLCC report, if you go all the way down to the bottom, there's a section where I added in some extra documents, and I believe it's the Portland Police filing that has that. And yeah, the right leaving and being followed, yeah, that no longer Cider Riot. But at that point, I haven't been hearing allegations of, or at least not very strong allegations of, the riot part of this taking place. It seemed to be focused on what happened on the sidewalk in front of Cider Riot and on the street, you know, when there was that 1v1 combat. One of the other things that I've noticed is, you know, by state regulation, Cider Riot should have bounced everyone who was involved in this for 24 hours because they engaged in disruptive behavior on premises. And it sounds like that didn't happen. But, you know, throw in the destruction of video evidence and all sorts of other stuff. I do kind of wonder, and this is, you know, not on topic to the trial, but kind of in the chat, you know, where there's all this talk of Jewish people. I almost kind of wonder what Patriot Prayer's feelings are of Marjorie Taylor Greene. I believe she's the one who threw around the conspiracy theory about the Jewish space laser. Wonder if the judge is taking extra time to deliberate on this, because he said he was going to be back with his decision at 11:30. It's now 11:43. Be this long, I would have put the music on. Why people, you know, take plea deals of how unpredictable, and I think that's why they're. Oh, looks like he's coming back.
We are back on on the record in WebEx unmuted.
Okay, we are on the record. All counsel and parties are present. We are outside the presence of the jury. A couple of things that apply to all of, or each of the defendants' motions for judgment of acquittal, and then taking up each motion in turn. The motions are all brought pursuant to ORS 136.445, which states that the court shall grant a motion for judgment of acquittal if the evidence introduced theretofore is such as would not support a verdict against the defendant. In making that determination, the court is required to give all factual inferences in favor of the state. That is to say, unlike when a jury is making its ultimate determination on this motion, if there are facts that could be read one way or the other, the court must read those facts in favor of the state. Fundamentally, the question is whether a reasonable juror could conclude as to each defendant, whether that defendant committed each and every element of the crime of riot. And we'll talk about those elements in a few minutes. Aside from those elements, there's ample evidence in this record from which a reasonable juror could determine or could conclude any number of things. There's certainly ample evidence from which a reasonable juror could conclude that each defendant in this trial decided that the best use of their time on what looks like it was a pleasant May afternoon, they decided that the thing they wanted to do was to go down and bother a group of people who were at that moment doing nothing more than minding their own business and enjoying their own company. There's ample evidence from which a reasonable juror could conclude that each defendant decided that the point of that exercise was to annoy, or what the internet would use, to troll this group of people, to walk right up to where that group of people was, to provoke the members of that group of people, to make the members of that group angry, and to play what I would call an adult version of I'm not touching you. But I can't say that because there wasn't very much adult about that conduct. There's ample evidence from which a reasonable juror could conclude that the violence that erupted that day wasn't an accident. It was part of the plan, as Mr. Gibson is heard saying on the video, oh no, they took the bait. That is to say, there's evidence that these defendants decided to bring a lit match right up to the gasoline, and then having sown seeds of disorder, were intending to figuratively walk away with their hands in their pockets because they didn't actually, quote unquote, do anything. And there's ample evidence from which a reasonable juror could conclude that the consequences of all of this behavior were serious. That it was not, as was suggested by one of the attorneys in opening statements, mere tomfoolery. So there's ample evidence, there's sufficient evidence from which a juror could determine lots of things. But the reality is that much of that evidence has very little to do with what's at issue in this trial and on these motions in these cases. These defendants are not charged with inciting anything, or with encouraging anything, or with provoking anything. In each of these cases, the district attorney presented to the grand jury for its consideration the charge of riot as to each defendant, and the grand jury issued indictments solely for the charge of riot for each defendant. That is to say, each defendant in this trial was charged only with the crime of having engaged in a riot, with rioting. So to resolve these motions, we need to look at what the charge of riot is in Oregon, and what are the elements of that. Well, in Oregon, ORS 166.015 defines riot, the crime of riot. And it says a person commits the crime of riot if, while participating with 5 or more other persons, that person engages in tumultuous and violent conduct and thereby intentionally or recklessly creates a grave risk of causing public alarm. So, 4 elements. While participating with 5 or more persons, engages in tumultuous and violent conduct, thereby intentionally or recklessly creates a grave risk of causing public alarm. The Oregon Supreme Court has made clear that in deciding that second element, determining whether or not a defendant has engaged in tumultuous and violent conduct, that statute proscribes or considers only physical actions, not speech. We've heard from a lot of lawyers a lot about speech in this case. Speech is not at issue in this case. As explained by the Oregon Supreme Court in State versus Shakarian in 1997, for the record, that's 325 or 370. At page 375, I'm now quoting the Oregon Supreme Court, which is binding on this court. ORS 166015 by its terms is not directed at speech at all, let alone at restraining the free expression of opinion or the right to speak freely on any subject. Rather, the statute is directed at a harm, the creation of a grave risk of public alarm. ORS 166015 by its terms proscribes only a certain type of conduct, conduct that is violent and tumultuous. To the extent the state suggested that speech can help contextualize that conduct, I do not think that that view is consistent with what the Oregon Supreme Court has said. And the Oregon Supreme Court has gone further. It said that expressive conduct, things like gestures, also cannot be considered in determining whether someone has committed the crime of riot. And so while there's a lot of concern about speech, there's been a lot of talking about speech. The one thing we know is that this case is not about speech. The one thing we know is that whether or not the evidence in this case is such that this case can survive a motion for judgment of acquittal, each case can survive, is that is that because no reasonable juror can consider the speech or expressive conduct, that cannot be used by the court in determining whether or not any particular charge survives or doesn't survive. So the question in each of these cases, which are only about riot, is whether or not each defendant committed or did not commit each element of the charge of riot. The one that I'm going to focus on is the one that all of the lawyers have already focused on, which is whether or not any particular defendant engaged in violent and tumultuous conduct. If they did, then the other factors would need to be considered. If they didn't, then that would be enough to end the case. If no reasonable juror could find that any particular defendant engaged in violent and tumultuous conduct, not speech, conduct, then the answer would be that no reasonable juror could find that the state had proved its case beyond a reasonable doubt, and the defendant's motion would have to be granted. What does violent and tumultuous conduct mean? Again, the Oregon Supreme Court provides an answer. Again, in Shakarian, now at page 378. Violent and tumultuous conduct is physical activity that reasonably is perceived by others as threatening an imminent breach of the peace. It's again physical activity that reasonably is perceived by others as threatening an imminent breach of the peace. So we now turn to each defendant's motion, beginning, we'll go in the order they were argued, and we'll begin with defendant Schultz. State says there are two occasions in the evidentiary record where Mr. Schultz engaged in physical activity that could reasonably be perceived by an observer to threaten an imminent breach of the peace. The first example is that, in the state's words, Mr. Schultz postured and that he was restrained while wagging his finger or pointing his finger. Well, obviously, the act of restraining isn't Mr. Schultz's. So we're left with posturing and pointing. The second occasion that the state points to as evidence that Mr. Schultz engaged in a physical activity that could reasonably be perceived by an observer to threaten an imminent breach of the peace is during the what folks have variously described as the one-on-one street fight or the street brawl. And the state points to Mr. Schultz pulling someone away, keeping two different people at two different times away from that brawl, and at least one point standing with his arms out. I am convinced that no reasonable juror could be perceived by others as threatening an imminent breach of the peace. Essentially, in this, runs the risk of being convicted of riot. Oregon's law clearly does not permit such an outcome. Because such an outcome is not allowable under Oregon law, no reasonable juror could on this record come to a different conclusion. I do not find this to be a close question. I am somewhat bewildered that the state has driven this case to this point, despite having all of the evidence in this case, all of the video in its possession for years. That's not a fling at the individual prosecutors in this case, who I know to both be men of enormous integrity and who are two of the hardest working and diligent and fair lawyers who practice in this courthouse. But as an institution, the district attorney's office's decision to push this case to trial is surprising, given the state of the evidence. Defendant Schultz's motion for judgment of acquittal is granted. With respect to Mr. Gibson, I find this to be a closer case. First, Mr. Buchal, on behalf of Mr. Gibson, again raises the First Amendment and argues that it would be violated were Mr. Gibson convicted in this case, because that could only happen with reference to punishing Mr. Gibson's protected speech or protected expression. I reject that argument, as I have consistently, because again, what we know is that the Oregon riot statute cannot and does not reach so far as speech. So that argument simply does not bear here. The record is overwhelming, and I suggest indisputable, that Mr. Gibson spoke obnoxiously to the crowd that was gathered at Cider Riot. He was provocative, he was taunting, he was acting like a troll. He repeated, "Do something," in a way that I think a reasonable juror would certainly be empowered to conclude was designed to try to provoke these people, if he could, into a reaction. And in fact, when that reaction comes, he behaves in that way. He gloats, "Oh no, they took the bait." He says, "Oh no," with a sarcastic emphasis on the no, on the "oh no, there's a riot at Cider Riot." But we've already talked about this. That is all speech. And as we've already seen, it has long been established as a matter of Oregon law that speech cannot be considered in deciding whether or not a defendant committed the crime of riot. So again, we are presented with the same initial question. Could any reasonable juror, giving all factual inferences in favor of the state, conclude that Mr. Gibson engaged in physical activity that reasonably was perceived by others as threatening an imminent breach of the peace? There are only a couple occasions where Mr. Gibson does anything that would qualify as physical activity other than standing or walking. One relates to what I've described as the street brawl or the one-on-one fight. For the same reason as with Mr. Schultz, I don't find that any of that could be reasonably understood by anybody as being violent and tumultuous. That's that either of those occasions could be read as violent or tumultuous. What we're left then really with is Mr. Gibson, when he is spat upon, taking his arm that has the spit and using it to rub against, or taking it and rubbing it against somebody from the Cider Riot group on his chest. Mr. Gibson says, "Do something," but of course, again, the "do something" is out. And so it's just the act of wiping that spit, a jury could plainly find that the person who received the wipe was doing it involuntarily. That person had not consented to that. It certainly strikes the court as a crime. That could, or at least it could be a crime. I suspect a charge of harassment that's an offensive touching, but that's not the crime that Mr. Gibson is charged with in this case. He's charged only and exclusively with riot. And so the question is, does that act of wiping spit from his arm onto that person's chest, inferring that that was involuntary, that he just touched that person and chose to do that, whether that is physical activity that reasonably was perceived by others as threatening an imminent breach of the peace. I take the state's argument seriously that in context, the state believes it could be. There are lots of people there. There are two groups pressed right up against each other. The state's view is that that was a potential match to the tinder. But at bottom, Mr. Gibson was moving just his arm while holding his phone. He did a thing that could plainly be read as offensive, but I do not think any reasonable juror could read it as being violent. As that word, or violent and tumultuous, as that phrase is used in the Oregon riot statute, as that statute has been interpreted by the Oregon Constitution. Because no reasonable juror could find that that act, which is the closest act we have, was violent and tumultuous, no reasonable juror could find that the state had proved beyond a reasonable doubt that Mr. Gibson had committed each and every element of the crime of riot. Mr. Gibson's motion for judgment of acquittal is granted. Mr. Lewis is a different case. There are a number of acts in the evidentiary record that suggest that from which a reasonable juror could tumultuous conduct. I think they all exist in Exhibit 2. They might exist in other exhibits as well. For my purposes, it is sufficient to say that a reasonable juror could find that the picking up of the discarded canister and I would say throwing it back hard into the crowd was violent and tumultuous. Likewise, a reasonable juror could find that Mr. Lewis's shove of the woman at about the 2:30 mark in Exhibit 2 was violent and tumultuous. Therefore, Mr. Lewis's motion for judgment of acquittal is denied because I find that a reasonable juror could, on the basis of the evidence in this record, find that the state had proved all elements of riot beyond a reasonable doubt. Is there anything else for the record at this time? We'll go off the record.
Well, so there we have it. 2 out of 3 acquitted. And yeah, like I just said in the YouTube chat, this is basically what, as I started looking into this case and seeing the evidence, this is about what I expected. When you pull all the speech out of it, I had trouble seeing the definition for riot. I think that there was definitely criminal activity, but the DA's office, and this was nothing about Mike Schmidt. This was when Rod Underhill was still the DA. He was the one who signed off on just charging them for riot. Not disorderly conduct, not harassment, not any of, whatever other charges this may have fit under. They would have had lower burdens of proof. And, like Judge Souede said, in Gibson's case, a harassment charge could have survived the motion for acquittal. Disorderly conduct, the street fighting, I personally think there would have been a really strong case for that. So, yeah, I guess they're off the record. They're probably getting ready for lunch, but they didn't give us a time when they're coming back. If they're going to come back today, because now that this has been decided, this may influence how Lewis's defense handles their defense, because they were probably leaning heavily on the testimony and evidence that would have been provided through Mr. Buchal with Joey Gibson, and I have no idea how that evidence has been set up, how much of it has to be reevaluated now because it's only one person. I don't know. A lot of that back office stuff wasn't addressed in front of the court that I saw, because in the pretrial motions last week we were so focused on the state's exhibits, wasn't seeing anything about defense exhibits. And like Alvin saying in chat, would never be another protest in Oregon again if they had charged Joey. I tend to agree, and Judge Souede, I think he stated it pretty accurately that if he had not, or if he had been taken to the full jury and convicted, that would have devastated free speech in Oregon. Every single anti-police protest would be, the cops would, all they'd have to say is this has been declared a riot, and charge everyone with riot, and they could just point to this case and say, here it is. And, taking a plea is still an option. That may be, obviously they're going to do a lunch and get some time before they do anything else, and it is entirely possible that the defense may recommend that he take a plea now that the other two have been thrown out. The acquittal's either going to make his case a lot easier or a lot harder, because now it's just him. One of the other questions that I think comes from coming from now that it's just Lewis is, how do they count the number of people involved for a riot? There were 6 people charged. 3 have now pled. 2 have been acquitted. 1 is still outstanding. And, if they only look at the people who were charged for constituting a riot, or if they're looking at the number of people who were there, and that's something I've had trouble understanding since I've been covering anti-police protests in 2020. There's a lot of cases that I saw where it was a single person brought up on a riot charge, or 2 people, without the matching indictments to bring it up to 5 people at a single incident. I've always presumed that they looked at the whole crowd and be like, okay, well, we didn't catch all these people, but there were enough people that it was 5 or more, or 6 or more, depending on, I guess the law changed at some point in all this. So, you know, if the idea is that it has to be, that everyone has to be charged for it to count, well, now we're at 4 people. That could also, you know, if that happened, that could also theoretically force re-looking at convictions for the others that already pled. But I really think, from my experience without being a criminal lawyer, without knowing all the case law, it really seems that it's the number of people engaged in the activity, whether they were convicted or not, is the determining factor. And in that, we have, you know, 3 to 4, definitely on the Patriot Prayer side. We have the bouncer from Cider Riot could be considered because he was the other participant in the street fight. We have any number of patrons at Cider Riot that could be considered. It's very easy to hit 6 people from what's in the video. And yeah, and as far as I don't know, you know, I'm looking in the YouTube chat, which I know isn't showing up on the other platforms. We're having problems with our chat system connecting to YouTube today. But it does seem that in the past I've seen that depending on criminal history, if there's not a lot of it or it's all low-level stuff, judges seem to be more prone to doing probation versus actual jail time. And keeping in mind I can only readily see Oregon, there was only this case. Let me see. Actually look at the jail intake interview. Can sometimes give. Yeah, when he was booked into Multnomah jail, they said no conviction history per records. So unless he got some conviction since August 14th, then he has no criminal history. Even if he is convicted, I think there's a very strong chance that it would be probation, possibly restriction from public protests. At the very least, if it's an unlawful protest while he's on probation, he would be forced to disperse. That's a pretty standard. But yeah, so that seems to be where we are at. I'm going to go ahead and shut the stream down for lunch. I'm not sure when exactly they're coming back. I'm going to plan to be ready for 1:30, since that's what they normally would look at, 1:30, somewhere in there. And hopefully we'll have a better idea when we get there. Everyone, thank you. Everyone that showed up to listen to or mostly watch this, because there was a lot of dead air today, even through the technical problems we had here and with the court. If you want to help us out over here, definitely in the link in the video description, we do have ways that you can support us. We're definitely going to be doing more of this kind of stuff. We've got a number of cases that are going to be coming up in the future that we are planning on getting permission to do the same live streaming with. And we can definitely use the assistance and support with that, here and going forward. But if you're just here for the Gibson part of it, you got your answer. He's free man. If he's back this afternoon, he's going to get to be in the gallery just watching to see what happens with Lewis. So for everyone else, take care. I will see you later.